The impact of alimony on SSI, how a divorce decree can accidentally reduce disability benefits. In many Utah divorce cases, alimony is intended to improve financial stability after the marriage ends. But when a child or spouse receives Supplemental Security Income, commonly called SSI, a standard alimony order can sometimes create serious unintended consequences. In some situations, alimony can reduce SSI benefits. In other situations, it can eliminate SSI eligibility altogether. And because many SSI recipients also depend on Medicaid, the problem can reach far beyond the monthly benefit payment. This is one of those areas where family law and federal benefits law overlap in ways many people do not fully understand until the damage has already been done. The first thing to understand is that SSI and SSDI are not the same thing. Social Security Disability Insurance, or SSDI, is generally based on the disabled person's work history and earnings record. It is not strictly needs-based. SSI is different. SSI is a needs-based federal program for disabled, blind, or elderly individuals with limited income and limited resources. Because eligibility depends heavily on financial need, the Social Security Administration looks closely at income and assets. That means support provisions in a divorce decree can materially affect eligibility. For SSI purposes, alimony is generally treated as unearned income. As a practical matter, direct cash alimony commonly reduces SSI benefits after applicable exclusions are applied. In some cases, the support may reduce benefits substantially. In other cases, it may eliminate SSI eligibility. That can create serious problems if the person also depends on Medicaid coverage, prescriptions, therapy, attendant care, or related services. This problem is not limited to disabled spouses. A disabled child receiving SSI benefits may also be affected if a custodial parent begins receiving substantial alimony. Federal SSI rules use a concept called deeming, meaning some of a parent's income may be attributed to the child when determining the child's SSI eligibility. Parents sometimes do not discover this until after the decree is entered and the child's benefits are reduced or terminated. That is why careful divorce planning matters. In some cases, a traditional monthly cash alimony payment may not be the best structure. Sometimes direct payment of certain third-party expenses may be considered, but even that has to be handled carefully. Payments for rent, mortgage, obligations, or utilities can still affect SSI because they may be treated as in-kind support and maintenance. Special needs, trusts, and ABLE accounts may help in some cases, but those tools are technical and have important limitations. The point is not that alimony should never be awarded when SSI is involved. The point is that the decree must be structured with benefits consequences in mind. A support order that looks favorable on paper can make the recipient worse off in real life. In divorce, more cash is not always more security.